welcome to our latest podcast edition. I'm thrilled to be joined by Michelle Last. She's a senior partner at Keystone Law, and she's also a top legal influencer on LinkedIn. So thank you so much for joining me today, Michelle. And essentially, the reason why we are running this podcast right now is because the Employment Rights Act 2025 really kicks in as we move through 2026 and into year 2027. And from so many conversations with clients, and we work with all different size businesses, there seems to be still a lot of confusion, lack of knowledge. So we've brought in Michelle with all of her experience in this area to talk through some of the key areas. So without further ado, let's kick things off. Michelle, if you wouldn't mind starting by telling us about the current tribunal case statistics and what's been happening since AI has become much more prevalent, and what you envisage those tribunal caseloads to look like with these new laws coming in. So over to you, please.
Yes, thank you for having me. So in the last year alone, tribunal caseload has effectively doubled. And I think with the changes that you've just mentioned that are coming into force from 1st of January 2027, I think we'll probably see a further sort of 200% increase on claims. And I think that's principally because we've got AI. So it's obviously easier than ever for people to file claims. It can be done sort of very quickly, not necessarily very well, but very quickly. With the changes that are coming into force in January, it means that there are going to be more people in scope who can bring claims, and the incentives to do so will be much bigger as well. And those are for the sort of key reasons that you've mentioned. So firstly, the unfair dismissal rights are going to be available to people who've got 6 months service instead of 2 years, which is a huge change. And secondly, unfair dismissal claims are going to be uncapped financially. So at the moment, up until sort of end of December, a claim for unfair dismissal is capped at the lower of a year's pay, or about 120k. So you can imagine the fact that cap is going to be lifted means that you're going to be getting more claims, and claims for a much bigger value. I should also say as well that the time limit for bringing a claim is going to be increased from 3 months to 6 months. Because people have up to 3 months use of the ACAS process as well, it may be that you're getting claims sort of 9 months even after the termination date. So the changes are the biggest changes I will have seen since I started practicing some sort of 23 years ago.
Wow. Okay, so yeah, this is kind of like a significant alert, warning, however you want to label it. And critically, these changes are coming in from January 2027 in relation to that. So that means that affects people that are starting now, right? In terms of current new hires that are being onboarded in a permanent capacity. Is that correct?
Absolutely. So I've actually written to my employer clients already and said, don't wait until January, because by then, arguably, it's too late anyway. I'm basically saying to employers, think about now about who you have in your workforce and whether they're the best people for your organization. So it's not just looking at people who maybe not performing well, even. It might just be that they're not the sort of perfect fit for you, because from January, it's going to be much harder to exit people. There's going to be much more of a focus on process. So it's really thinking, are there decisions that I would probably otherwise delay, but I'm having to make sooner? The other thing is to sort of really get your processes bedded in so that when you do have performance or conduct issues in the future, you're sort of better prepared to deal with those, because you've got good policies and procedures in place, and you follow good processes when you're looking to exit people for those reasons. So the worst thing employers could do really is just to sit and wait for the changes to come in. I think it's worth having a conscious sort of focus session internally to say to all of your teams and your managers, who are the people who are performing well that we want to keep, and where do we see the issues lying? Because even if somebody has more than 2 years service at the moment, it might still be more cost effective to exit them before the end of the year than, say, waiting till they might then, well, they would then have an unfair dismissal claim, which is going to be uncapped. So yeah, taking action now might prevent much bigger issues in the long run.
Absolutely, indeed. And I guess this will fundamentally change how employers onboard and manage people in the first 6 months. right? So I know you've
Mm.
written to your clients. What action specifically do you advise, apart from that initial meeting on assessing, fit, I guess, in the wider business and across teams? What are you advising your clients to take heed?
Yeah, so lots of things really. So effectively, you're going to have much less time to road test staff to see whether they're a good fit for your business, both in terms of performance and sort of conduct and culture. So there's going to be a much bigger pressure on carrying out really good, effective onboarding processes. I said you're not going to have that 2-year grace period going forward to see whether someone's the right fit for you. So you're going to have to make better decisions in the beginning, and that in itself can be quite a big change for organizations, making sure you're doing proper background checks, making sure you're actually following up on reference checks, that kind of thing, having good relationships with good recruiters that you can trust. Um, then when you do have people onboarded, making sure you've got your contract in place, making sure you've got a good contract that's been updated to reflect the changes that are coming in next year, and that have already been introduced, and also having a really good sort of disciplinary policy as well, so that you're very clear on what amounts to misconduct within your workplace. And then it's kind of managing people more effectively when they're coming in. A lot of employers take a very laid back approach to managing staff presently, but really that's going to have to tighten up a lot, certainly by January at the latest. Effectively, what you need then is to have more of a kind of a process where you're having regular check-ins with those people that you've just onboarded. And this is especially for people who've got less than 6 months service. So it's not simply scheduling a probationary review meeting at month 5 or 6. It's perhaps having sort of regular, maybe even weekly or fortnightly 5-minute check-ins with the individuals to make sure that where they're sort of not meeting the standards, you're addressing that. And I'm recommending to my clients that they record those meetings with AI so that you can have recorded outcomes from those meetings, so that there's no dispute about whether you've raised an issue and whether there were sort of performance or conduct issues. So ideally, at the end of that kind of review period, you're making a decision by sort of the 5-month mark as to whether you want to keep someone. And if you don't, then you've got sort of a good history and a good record of the things that you flagged where it wasn't working out, which should help to defend against any allegations that maybe there's an unfair reason for termination before the end of that 6 months.
Absolutely. And certainly, I concur with that. I'm talking to clients a lot of the time, and, they're aware, as I say, of some laws coming in. They don't exactly know the detail, hence why we are putting this topic out today. But it just seems that businesses are still operating with management practices that are designed for a very different employment law environment.
Mm.
And I think from what you've just said, documentation of processes is a non-negotiable, right? It's critical. And I guess, from your clients, what do you believe is the biggest misconception employers currently have around these new laws and how they're operating?
I think there's the sort of wait and see approach is a massive issue for employers that aren't
Okay.
taking action now. But I think also this is sort of wait and see approach isn't addressing the kind of key things that you would be doing now if you're sort of thinking about it and you're planning to be prepared, so that you're not going to come a cropper when the rules change. It's things like implementing manager training, because I do find quite consistently that a lot of, especially sort of mid and senior level managers who aren't necessarily the most senior managers, but they're not necessarily well trained on how to have these difficult conversations. So as I said, it's really going to be having regular check-ins with staff going forward. And for some managers, they're just not well prepared and well trained to have those difficult conversations, and they need to get used to having them sort of more regularly. It's those people who are actually going to be bearing the brunt of making sure that you have a fair process when you're terminating people. It's also having really good documentation in place. So with my clients I've been working with, I've been reviewing their contract to make sure that it sort of puts them in the best position possible, really, so that if they want to terminate, that they're in the best position that they can. They've got to have a really robust disciplinary policy, which is very prescriptive about the things that are not acceptable, as well as broad enough to capture things that we can't imagine people might get up to. Is having really good onboarding processes. So, as I said, it's going to be much more risky to just take a chance on individuals. So it's making sure that you're really sort of vetting your candidates. I appreciate it takes a lot of time to do that, but the time that you would then spend dealing with people who are not the right fit for your business and the potential risk of claims is going to far outweigh just doing it well in the first place. There's also going to be quite a lot of time taken up with managers with just having these conversations with staff,
Mm.
especially as I said, people who've got less than 6 months service, and the record keeping. So again, that might be a change in practice, that you're having these regular check-ins, but you're also recording the outputs of those meetings. I've recommended to clients using AI, having a folder for each individual employee and just copying the notes from those check-ins into the folder for the individual, so you've got that information to hand if you need to use it. But there's quite a lot of change really for employers in terms of how they're managing staff and more proactively managing staff going forward.
Significant change indeed. And I think, there's going to be some very, very busy, not just line managers who are already operating in very lean teams, right? Because, the economic environment is challenging, but those with HR teams, and that's businesses of all sizes, they're obviously going to be incredibly busy as well. So I think harnessing AI, making it a company-wide mandate, if you like, in terms of the manager training and the documented one-to-ones, seems to be a complete non-negotiable, so that you can make sure your processes are as robust as possible. I think there seems to be a lot of this, as you said, let's wait and see. But a lot of clients I've spoken to, the kind of the ethos is, oh, I think we're probably okay in terms of their processes and employment contracts and everything else, but probably okay until they're not, right? So,
Mm.
and this is where I think the tribunal caseloads are going to increase. It's
Mm.
probably because of lack of documentation and process that is going to allow for such tribunal cases to go ahead. And then just in terms of the hiring implications, because obviously us as a recruitment business, I think this is going to be quite a shift. We're already seeing quite an increase in demand for interim contract hires, temporary to permanent hires, that we label it temp to perm, because again, I think clients want that security of trying before they buy, in
Mm.
light of those that are aware of the employment law changes that are coming in, and certainly those clients that become more aware, especially after this podcast, of how much they're going to change the business and hiring practices. I think we're going to see an uptick in interim resource. What would you advise employers should do before making a permanent hire now?
I think you're right. I think we're going to see a huge exodus of people before the end of the year, with employers who are sort of embracing the advice that I've given on this podcast, which is that really to review people to make sure that they're the best fit for your organization. So I think there's going to be a massive surplus of people on the market by the end of this year. Um, and I think it's sensible for employers to assess sort of who is available on the market. Working with a really good recruiter, I think, is a very good idea. Organizations that don't have a relationship with a recruiter they trust, I recommend they get that in place before the end of the year. And also with HR advisors, if you don't have an internal HR advisor or even an external one, you might want to sort of tee someone up so that you're ready. In terms of engaging people on an employment contract, but on an interim basis, so the key thing to note is that they're still employees if you're taking them on an interim basis. But I think there's a really good place, and I think it will be a growing trend that employers will have more interim appointments. You still, from a contractual perspective, would have to agree like a termination date, or that you would give notice. But the benefit with interim is that the person is really on notice from day one, that they're effectively, it's a 3-month, 6-month kind of trial period. So hopefully that person would be performing optimally. So I think it's quite a good way for employers to road test, to try before you buy, as you would say.
Absolutely. I think trying before you buy is certainly an option. So it'll be interesting to see how that hiring trend continues, or otherwise,
Mm.
as we go into the second half of the year. But also your point, obviously, about the recruitment company, a really trusted recruitment partner. Obviously, it's critical. At Talent Edge here, we're really proud of our rigorous interviewing and referencing process. And, hopefully those clients that partner with us, will be testament to that. But if, as you say, if you haven't yet found a recruiter to work with, you need to make sure that needs to be one of the selection criteria. They are, fastidious about their referencing and everything else, because that will be a massive help with all these other elements that busy line managers and busy HR teams are going to have to be involved with in relation to hiring, for sure. So I guess finally, moving on then, how would you summarize, I suppose, what are the 5 things that you are absolutely urging as a takeaway from this, urging your clients to do right now, given that these laws are coming in imminently?
Yes, so obviously we touched on some of them already. So it's
Yes.
doing a really good documentation review, and probably for that you would need to engage a lawyer or a HR professional.
Yeah.
So it's looking at things like probationary period, your notice period, sick pay entitlement, and then on your policies, it's really focusing, I think, especially on your disciplinary policy. So the disciplinary policy that I've developed with clients has a really long list of things that constitute misconduct. And also it has sort of catch-all provisions as well, which, like I said, intended to cover things that we can't imagine that people get up to that they do. So that's point one. And point two is really training your managers and being sympathetic to managers and thinking, what are the tools, the soft skills that these people need to be able to sort of manage people properly? It's around things like sort of being consistent with handling matters, addressing matters directly, not being afraid to engage in communications about performance conduct issues, and then, as I said, documenting discussions that you actually have had. And then thirdly, tightening onboarding processes and reference checks, making sure you're really picking the right people in the first place, and then doing really good background checks on those people, actually making sure you're getting those references. If you're not getting references, sometimes that could be a sign that things have gone wrong. Also, finding more and more individuals changing their names. So if there's been a name change, for instance, question why that's taken place. Becoming more of a documentation culture, so that when you are having these conversations, you're documenting them. And because often claims are lost because you haven't gone through a proper process, or you have had that conversation but you haven't documented it. That sort of happens quite a lot. And
Yeah.
then I'd say finally, and I think this is the really key thing to take away, is really reassessing your workforce now and asking yourself whether you've got the right people in the right roles. Like we said, whether that person should be in a permanent role, whether it should be an interim role, thinking about using contractors, especially if you've got sort of fluctuations in business need and demands, having sort of specialist training if you need people to do very specific roles, but just not shying away as well. Even now, if you've got somebody who's even been with you for a few years, but they're consistently doing things that are sort of not optimum, maybe they're just never quite reaching their objectives, that kind of thing, or they're consistently late, or their attitude is not great. If you're delaying dealing with those people until next year, then those claims will then be sort of potentially financially uncapped. So it's about having confidence to make decisions and to sort of deal with people in a constructive way. I think especially with COVID, there's been quite a trend of employers feeling like they don't have the right to take action. Maybe if somebody's sort of taking advantage of flexibility or just not complying with your requirements to be in the office, those kind of things. And now is kind of your best time. There's never going to be a better time than now and to the rest of the year to sort of, like I said, really put in place proper processes and procedures and making sure that everyone knows what good performance and good conduct looks like, and that people who don't meet that criteria, that you're taking action now rather than delaying a problem, because it's going to become a much bigger issue to try and deal with it from sort of next year onwards.